prosecution shall be the truth, nothing but the truth, so help me God. 80977, Corporal Amos Ndonyi of DCI, Bangi Fraud Investigation Unit, and I'm the eye of this case. Your Honor, I'm investigating a case of conspiracy to defraud, honor to section 317 of the Penal Code, and stealing, honor to section 268(1), as said with section 275 of the Penal Code. Yes, Your Honor, the respondent was before the court is a person of interest in respect to the investigation which are investigating of the said offences. And that, Your Honor, the offences which were committed on the first date between 6th June 2025 and 14th June 2025 at a known place within the Republic of Kenya, where the respondent, generally with us not before court or at lunch, conspired to defraud NCBA Bank a total of $4,046 US, which is equivalent to Kenyan shillings 57 million. 57,534,000. Yes, Your Honor. The respondent, being an employee of Rainfall Digital Limited as a software developer consultant, which is contracted by NCBA Bank to do system maintenance and upgrading of mobile banking platform and retail banking of the Rwanda NCBA subdivision branch, UCMTN banking, MTN mobile network of Rwanda. Your Honor, the respondent was before court, having called to assess the system of the bank on 6th June this year at around 05:33 hours, did an amendment that implemented through logic change, which caused the integration service to consistently return a success status in all ATN withdrawal requests, even when the funds were insufficient or the account does not exist. Your Honor, the respondent, following the illegal implementations of the amendments, around 70 customers in Rwanda initiated 260 transactions, resulting to the loss of the said amount. Third, Your Honor, through the action or inaction of the respondent, the complainant lost the said amount of money. Your Honor, the matter was reported at the Security and Investigation Department of the bank that the same was assigned to the bank found for further investigations, and that the Honor on 16th day of June 2025 the respondent, while at NCBA headquarters within Nairobi, was detained, and the officers from the Bank Front unit were conducted swiftly, where the respondent was escorted to the Bank Front office for further police action. Your Honor, the investigations are still going on, and the complexity of the matter of the investigations are not need more time to finalize the investigations. In particular, noting the technical expertise of the respondent, who is a software developer, there's a possibility that he will gain access into the system, which may result into more loss of funds to the bank and its clients. Your Honor, the respondent is still in possession of the bank's access logs, remote servers, and passwords, which is set to hand over, and also we need to record detailed statement of the respondent. Your Honor, the respondent is likely to interfere with the witnesses who are yet to record statement and compromise, tamper, or delete crucial digital evidence. Due to the seriousness of the offense, preliminary investigators have established that he is working in cohorts with other persons and is likely to collude with the said accomplice, resulting further loss. Your Honor, owing to the huge financial loss, totaling to over 57 million, and the number of clients affected, I believe further loss may occur if the investigations are not complete. So, Your Honor, I'm praying this honorable court to allow me to detain the respondent for a period of 10 days at Capitol Hill Police Station to allow completion of investigations. That's all, Your Honor.
Your Honor, it should go on record that even the application for detention that is being argued before you was not served on the respondent or even on his counsel. Yes. Your Honor, I just want that to go on record because I've heard the contents of that application, and I believe it is one that I can respond to immediately now.
If you need time,
yes.
If you just serve, then I can give you time to respond. But if you are good to go, then you can proceed.
Yes, I was just bringing it to.
The fact that you were just served.
Yes, I wish to proceed. I was just bringing it to the attention of the court. Your Honor, the grounds that have been advanced by the investigating officer are not compelling enough. Your Honor, the investigating officer has clearly informed this court that the respondent is an employee of a company. The respondent has also cooperated with the investigating officer who are already in custody of his mobile phones and his laptop. Your Honor, this is an offense that is a cross-border offense, as some of the offense was committed allegedly via the computer system, which we believe that the respondent has since lost control of that system and is not able to interfere with any investigation that is going to be done. You know, we believe that this is we pray that the respondent be released on personal bond or on reasonable bond terms pending the investigations. That will be all.
There is a very high likelihood that the respondent will tamper with the evidence, especially now that the IO has confirmed that the bank's access log, remote servers, and passwords are still in the custody of the respondent. And given his expertise, if he is released on cash bail or bond, there would be nothing preventing him from accessing the same. All he would need is a laptop or a computer. You know, given the amount that is in question that has been lost, and also given the complex nature of the investigations, because I'm sure the BFIU would need to get experts, and I pray that the respondent is detained for 10 days at Capitol Hill Police Station to allow the investigating officer and his team conduct thorough investigations. That is all, Your Honor.
All right, so a brief determination on the application by the investigation dated a notice of motion application dated the 17th day of June 2025 that states principally that the respondent hearing to be detained for a period of 10 days to enable the investigation conclude the investigation. I've also considered the supporting affidavit sworn by the lead IO, who was the deponent who is on the dock. I've also considered the opposition thereto by the learned counsel on behalf of the respondent. So having considered and appreciated the complexity of the investigation involved vis-a-vis the expertise of the respondents, which is not in doubt, I find the application to be merited and competent to the extent that the respondent would be detained for a period of 5 days at the Capitol Hill Police Station. So I've granted the pre-trial detention for 5 days. So we'll mention it on, so the 5 days will be working days. So we mention on the 24th of June, 2025. Okay, thank you, Councillor.